Good afternoon, everybody. We think we're live here. Thank you for bearing with us for a couple of minutes. Just a reminder, to the extent there's any background noise, and to ensure that there isn't any interference on the participant's end, can you please make sure that any phones or computer microphones are muted? So thank you again for joining us. My name is Jamie Dreher. I'm a partner at Downing Brand in our commercial and financial and restructuring practice. I'm going to moderate a little bit. We're going to jump right into it. We hope that what we're offering today will be helpful to you in these kind of unprecedented times. Our business and our clients' businesses are facing some of the same issues that you all are facing. We've done some deep dives into a lot of current issues. We are glad to have you with us. During the webinar, as we are speaking, there's going to be a chat function. I think it's in blue at the bottom of your screen. Go ahead and type in questions. They will show up on our end. We're going to reserve about 5 minutes at the end to try to answer a few of those questions, but please feel free to do that. After we're done this afternoon, we are going to be hosting a weekly series on Fridays. If there's any substantive content that you or your clients or your groups are interested in, please feel free to reach out to any of us on the line this afternoon. That will help us kind of tailor content to what people are looking for. So without further ado, let me go over the agenda just very briefly, the topics that we're going to hit today. I'm about to turn the floor over to our managing partner, Scott Shapiro. He's going to talk about current executive order compliance orders that have been issued from the government with respect to workplace issues. One of our employment partners, Liz Stallard, is going to talk about and update you all on this very fast-moving employment law and regulatory environment. Our family law partner, Kelly Pope, is going to be talking about family law issues in the current environment and what's happening. And then I'm going to finish with a few minutes on, I think I'm going to start with talking about the legislation that was passed about an hour ago and is about to be signed and try to hit some highlights for people. If we have time, we're also going to discuss some insurance coverage issues and other commercial issues. We will try to limit this to an hour just to respect everybody's time and our schedule. So without further ado, Scott.
Thank you, Jamie. Good afternoon, everyone. My name is Scott Shapiro. I'm a partner here at Downing Brand and practice in the area of flood protection and water supply. And in that role, and also in my role as managing partner, I've had to get a handle on what it means to be sheltering in place and how businesses comply with that rule and what the exceptions are. I'm going to talk a little bit about 4 different documents that exist in the marketplace of ideas right now, and then talk a little bit about how they apply and try to explain some of the nuances of them to you. The 4 documents that I'm going to reference are actually all on our website. They're on the page that's dedicated to this webinar, and you're welcome to download them and take a look at them there. Liz Stollard will be talking next, also as a document that she's posted up there, and so it's a good resource for you to take a look at, and I think we'll probably provide those resources in the future as well for other webinars. So the first document is an example of a county order on shelter in place. And I just happened to grab the Yolo County one because it was one of the later ones, but they're all pretty similar. As you're probably aware, this started, the shelter in place requirement started with the 6 Bay Area counties. It later was extended to 12. Yolo County subsequently issued one. Sacramento County issued one. Placer County issued one. And they're all pretty similar, although a little different. But for purposes of the conversation today, the material I'm going to talk about is the same in all of them. The one from Yolo County was issued on March 18th. The next I'm going to end up talking about Executive Order N3320. That's the governor's executive order ordering shelter in place for the entire state, and that was issued on March 19th. The third document I'm going to talk about is the U.S. Department of Homeland Security Cybersecurity and Infrastructure Security Agency document. issued on March 19th. It's also known as the CISA document, again, Cybersecurity and Infrastructure Security Agency. And it's a memorandum that tries to identify what the federal government considers as essential critical infrastructure. And then finally, I'm going to talk about the March 22nd document, which was issued by our state public health officer, providing more clarity on the issue of who are the workers that are in essential critical infrastructure. So those are the 4 documents, and I'm going to take this largely chronologically because it's the way to best understand both the evolution but some of the confusion that still exists in the marketplace. So as a preliminary matter, all of this is self-policing. There's no very clear guidance from any state or federal entity yet that clearly tells you whether you are in a critical, essential infrastructure area or not. I have heard some stories, I'm not sure if they're urban legends or not, of sheriff or CHP pulling people over. The more I look into it, it seems more like someone was speeding, and when they were speeding, they were told they shouldn't be out on the road, or the high school teenagers who were sitting in a parking lot at the high school who were told, no, they shouldn't be necking, and actually they should not be here, and they should be sheltering in place. So I'm not seeing any sort of National Guard or CHP or sheriff organized attempt right now at mandating shelter in place, and so it is a bit of an honor system. The second thing to point out is none of this really talks to whether your business can continue to operate. The question is where can your business operate? So if you look, for example, at the Yolo County order, you'll see that the goal of it is to ensure the maximum number of people shelter in place in their places of residence to the maximum extent feasible, while enabling essential services to continue to slow the spread of the virus. And then it goes on to say that all businesses with a facility in the county, because this again is Yolo County, are required to cease all activities at facilities located within the county, except as otherwise provided. And what that means is you can still keep working at your home if you'd like, and the orders all say very clearly you can work in your residence, but the real question is can you have people at the office still? Can you have people out in the streets? Can you have people out in the field? And the thing I really liked about the county orders were not only did they indicate areas that were essential businesses with lists like healthcare, sanitation, gas stations, newspapers, etc., they also had a really important exception which said that you can continue to operate at a business location to provide minimum basic operations. And minimum basic operations required social distance, but it did allow that you could have people at an office, the minimum necessary activities to facilitate employees of the business being able to continue to work remotely from their residences. So I'll apply it to our law firm. We have about 150 people. We have, over the last few days, about 120, 125 working from home, and we have 20, 25 in the office because they are facilitating the rest of us working from home. They are running RIS, they are opening the mail, they are docketing any court dates that might still exist, they are cashing checks, they are issuing payroll. All those things need to keep happening, and so the minimum basic operation exception provides for that. When the governor issued his order, Executive Order N33-20, it kind of ignored those basic operational issues. And what it basically was is a very short order, really only one paragraph, saying all residents are directed to immediately heed the current state public health directives, which I ordered the Department of Public Health to develop. And then there's a page and a half from the public health officer with what the public health officer said is required. I think it's Dr. Angel. And so when you read that, what it requires is that all individuals living in the state of California stay home or at their place of residence, except as needed to maintain continuity of operations of the federal critical infrastructure sectors outlined on this webpage. And I thought, okay, great, we're going to have great clarification. And I went to that webpage, and it had 16 different critical infrastructure areas, including interesting ones like arenas and ballparks and state fairs and amusement parks, which were all listed amongst critical infrastructure, because this was originally designed as a list to deal with things like hurricane evacuation and other issues like that. And so we immediately ran into this problem where the guidance was basically saying so many people need to be home, but if you're running an amusement park, you can still be there even though the amusement park is shut down. And we lived under that ambiguity for a few days until finally CISA issued this March 19th order. And the March 19th order lists identified workers who conduct a range of operations and services that are considered essential to continue critical infrastructure viability, including staffing operations centers, maintaining and repairing critical infrastructure, operating call centers, working construction, and performing management functions, amongst others. And when you look at the list of 16 different areas, you'll see that it's a pretty good list, although there's a bunch of areas that really aren't clearly called out. The federal guidance, importantly, is advisory in nature only. It is not mandatory. And you should remember that at a federal level, there is no federal directive to shelter at home. There's only suggestions at the federal level. And so you can look at that list and you can see that it includes industries such as healthcare, it includes industries such as food and agriculture, law enforcement, energy, water and wastewater, transportation and logistics, public works, communications and information technology, other community-based government operations, critical manufacturing, hazardous materials, financial services, chemical, and defense industrial base. And again, these documents are contained on our website on the page specific to our webinar. We're not sharing them on the screen right now due to the volume and complexity of these documents. So the final document I want to talk about is the March 22nd document, again, that's on our website, on the page dedicated to this webinar. And this is our own state document indicating what those essential areas are. And it's more expansive than the federal list. It includes, for example, animal control officers and humane officers, which is not on the federal list. It includes county workers responding to abuse and neglect of children, which is not on the federal list. But in all of this, there are several industries that are not clearly addressed. For example, accountants, lawyers, and other consultants. And so the position we've been taking with our employees is that we may not be a critical essential service, but we are required for the operation of certain critical essential services. In my practice, for example, working on flood protection, which is public safety, or in my practice working on water supply, which is a utility. And so for those reasons, and because it's self-policing, you need to have some level of interpretation about whether this is going to work and what level you're going to comply with. But at the end of the day, if you review these documents, and you take a look at the key categories, you can get a sense of what the federal and state government thinks are proper industries that would allow you to be working from the office instead of from your home. And if you're not in one of those categories and you're not supporting one of those categories, the safest course is to operate your business from your home. So thank you, appreciate the chance to share that. We'll reserve some time at the end for questions. And I'm gonna introduce Liz Stollard now, who's gonna talk about the employment update.
Thank you, Scott. As Scott mentioned, my name is Liz Stollard. I'm a partner in the employment group here at Downey Brand. I hope everyone is safe and well at home right now. And given that the odds are pretty good that what I'm telling you may change by the end of this webinar, I'm going to do my best to cover some of the basic and honestly the most frequent questions that we've been getting recently with respect to the changes in the federal law in particular and how you can be prepared to address these changes when they go into effect next week. So the first question I put on our list was, what is the new federal paid sick leave benefit and how is that different from what we're already doing here in California? As it comes to no surprise to most of you, we're dealing with a federal requirement that is intended to cover all states regardless of what is already happening here. And as you're well aware, in California, we already have a paid sick leave benefit. And so it's important that you remember that we have the obligation to comply with federal law, but we also have the obligation to comply with existing state law. And so first, I want to walk through the requirements of the new federal requirement that's coming out of the Families First Coronavirus Response Act legislation signed into law last week. So the first thing to tell you is that the Department of Labor has now confirmed that these requirements go into effect as of April 1, 2020. For those of you who may have been reading online or getting different, bulletins from various sources, there was some confusion with respect to even when these requirements would go into effect, not later than April 2nd, immediately, things like that. It's important that one takeaway you all have is April 1st is the confirmed date according to the Department of Labor. And so you should assume that these benefits go into effect as of that date. The next thing I want to report to all of you is that the Department of Labor has also issued an informational poster with respect to benefits available to employees covered by the Families First Coronavirus Response Act. That poster is available at the DOL website, but as Scott mentioned, we also have made a copy of the poster available on our website. It's important that if you're a covered employer, and that means you're a private employer, 500 or fewer employees, and private sector employer, I'll say, with fewer than 500 employees, and certain public sector employers, you're required to post this notice in a conspicuous place at your workplace. And so it's important that you get a copy of this notice if you're a covered employer and that you make it available to your employees, similar to how you make other required labor law notices available. Some of you may be wondering, well, how do I do that if everyone's home? Or how do I do that if my business is closed? There has been some guidance issued on that. Generally speaking, I would say if you are an open business, you're going to put these posters in the conspicuous locations that you normally do. And if you have break rooms, things like that, in your various facilities, that's where these posters should go. In the alternative, and particularly if you have employees at home, you should be sending these posters out either via email or direct mailing in order to make sure that all of your employees receive them. In the alternative, the guidance also suggests that if you have an employee informational website, for example, on your intranet or on your extranet, that you could post the notice there and thereby comply. But of course, I would encourage you to make sure your employees know to check that bulletin board so that you can demonstrate that you've provided that information to them. With respect to the specific paid sick leave benefit, and as the poster details, and I'll do my best rendition of explaining a poster to you right now, the poster indicates and breaks down the buckets of leave. The way the paid sick leave benefit works is that it's requiring employers to pay, and I just want to stress that, you will be responsible for paying that leave, and the leave is for up to 2 weeks, which is 80 hours of pay or the equivalent for your part-time employees that they would work in a 2-week period. And you're going to pay it based on either 100% pay. To be clear, it's the regular rate of pay in that situation. It's going to be capped at $511 a day or $5,110 total. If that employee is subject to either a federal, state, or local quarantine or isolation order related to COVID-19, or has been advised by a healthcare provider to self-quarantine related to COVID-19, or is experiencing COVID-19 symptoms and is in the process of seeking a medical diagnosis. So that's the 100% pay with the caps I just described. You're required to pay 2/3 of pay, capped at $200 a day or $2,000 total if your employee falls into one of these buckets. They're either caring for an individual that's been subject to one of those orders or self-quarantines, they're caring for a child whose school or place of care or care provider is closed or unavailable due to COVID-19 related reasons, or if that individual is experiencing any other substantially similar condition as identified by HHS, that's essentially a catch-all provision. But again, that puts in place a 2/3 requirement for you to pay out as sick leave. The way that this is going to work, and as IRS guidance has indicated, employers are going to essentially receive a payroll tax credit in order to make these leave credits. So what that means is that if an individual, you're paying out this leave and you otherwise have to make Medicare and Social Security payments on your quarterly basis, you're going to be entitled to deduct the full value of these payments that you're making up to the caps that are detailed in the law, and you'll be able to take those as an immediate credit off of the money that you otherwise would provide to the IRS. In the event that the amount of money you're paying out exceeds the amount of payroll tax that's due, the guidance suggests that there'll be a sort of fast-tracked refund process where the IRS will then refund that money to you to make up for the fact that you're making those payments. So bottom line is you're basically going to get to keep the money you would otherwise pay and divert it toward making these paid sick leave payments. There's also, there are provisions in the law that indicate that employers with fewer than 50 employees may be able to exempt themselves from these paid sick leave requirements in the event that essentially a significant financial hardship would result by complying. the DOL, at least as early as this morning, had not yet issued guidance. They're supposed to issue regulations that detail how those exemptions might be provided, and they would be exemptions that the employer would have to apply for and receive in order to not have to comply with these requirements. So that's still an area that's up in the air, and we don't know exactly how those exemptions may work. The reality of that may mean that you should start thinking about how you will comply with this requirement until we know whether or not, in fact, you might be eligible for one of those exemptions if you fall into that bucket of employers. So in terms of how this matches up with what we already do in California, one notable difference, of course, is this paid sick leave benefit does not require a minimum employment requirement. As you know, in California, we have a minimum of 30 days of employment requirement in order to receive the sick leave, and a minimum of 90 days of employment before you can use it. Those requirements are not included in this paid emergency sick leave provision, and so you should not enforce this like California paid sick leave law with respect to those minimums. The only other thing I would note just generally is that, again, California paid sick leave is still available to your employees, so they can utilize both kinds of leave so long as they meet the applicable requirements for each kind of leave, and that's how you should calculate it moving forward in the next few weeks. So the next question that I have on my list is to tell you a little bit about the status of the changes to the Family and Medical Leave Act that also resulted from the Families First Coronavirus Act legislation. So again, as I've already mentioned, the first thing to remember is that that too will go into effect as of April 1st, 2020. That's when this obligation will exist. The next thing to remember is, again, this information is addressed in that DOL poster that you have an obligation to share with your employees if you are a covered employer. And then the third thing, which I think maybe has not been clear and I want to make sure to address, is that this expanded Family Medical Leave Act benefit does not now make all FMLA paid leave. As you know, FMLA ordinarily is an unpaid protected leave benefit. This expansion to provide paid family leave only covers one of the buckets of individuals identified in the Families First Act, those individuals who need to stay home to care for their child whose school or place of care is unavailable due to COVID-19 related issues. And so again, that expanded leave benefit doesn't hit everybody, it only covers that one particular category. That leave benefit amounts to essentially an additional up to $10,000 that is paid at a 2/3 rate to individuals who qualify in that category. The FMLA does require a minimum employment requirement of 30 days, and so that's also something you should keep in mind in terms of determining who is eligible. And then just to explain, for example, if you had someone who was home for that reason and you might be wondering, well, so do they get the paid sick leave or do they get the FMLA expansion or both? The answer is both. They're eligible to receive both. The FMLA benefit is unpaid for the first 14 days. Essentially, they could get the paid sick leave benefit to cover their first 2 weeks at 2/3 pay, and then starting on after the first 2 weeks, they would then be eligible for that 2/3 pay under the FMLA expansion up to the maximum of 12 weeks or capped at 12,000 total, meaning the 2,000 under the paid sick leave and an additional 10,000 under the FMLA expansion. And then finally, the last question I have on here is with respect to what benefits are available to workers whose hours have been or will be reduced. Initially, of course, we know that we have standard benefits available in the state of California to workers that come through the unemployment insurance program. Those benefits are not only for employees who are laid off or completely, separated from employment, but it's also available as a source of partial wage replacement. And in fact, you may already have employees who are seeking those benefits for reductions in hours due to recent changes, obviously, in operations. Another aspect of the EDD's, service available, if you are looking at significant reductions in force, is the EDD work share program. Essentially, the work share program is a way that you can work with EDD, assuming you meet certain requirements in terms of how many employees are impacted and by how much you're reducing their workload, where you basically work with EDD to coordinate the unemployment insurance payment. You reduce the hours by 20%, EDD gives them 20% unemployment insurance benefit, and you meet certain requirements to have a program in place so that they remain employed, and yet you continue to help them supplement their income for that remainder. I do know that one of the stimulus packages that was passed by Congress pushed out additional resources for state EDD work share programs like this one. I'll be honest with you, it's not entirely clear to me how robust their ability to process those programs is right now and maybe in the immediate future. And so it's certainly something that if you think you might want to pursue that program, the reality is it may be a matter of calling up EDD, finding out what you can do, finding out what resources may be available so that you can try and implement that in your own workplace. The last thing I'll note is for those of you who've been following the various stimulus packages going through Congress, just I think right before we started this webinar, the House passed the most recent stimulus bill that has already been through the Senate. That bill provides for an expansion of unemployment benefits as well. Essentially what it's going to do is it's going to add another $600 on top of the weekly benefit for all employees who are receiving unemployment insurance. It also expands coverage to self-employed individuals and part-time individuals. Just for clarification, again, this is one of those situations where the federal law is trying to cover everyone regardless of whether or not the state scheme already provided that coverage. As you're probably aware, in California, there are minimum income requirements that trigger the entitlement to unemployment insurance, and so we don't generally have that same issue about part-time employees so long as they meet that minimum. However, the law is confirming that because some states do not allow part-time employees to do so, they're going to be covered by this law. The law is going to be, it's going to extend this period of essentially additional unemployment benefits for up to 4 months. Again, in California, you're entitled to receive up to 26 weeks of unemployment. So theoretically, that's going to cover, you know, a good chunk of that time period. And we'll have to see with respect to how this shakes out with the benefit. It looks like it may be something that comes out as a separate check, kind of in addition to what individuals might otherwise receive from EDD. And so with that ridiculous amount of information that hopefully will remain the same until next week's webinar, I will go ahead and pass it over to my colleague, Kelly Pope.
Hi there. So I'm Kelly Pope. I'm a litigation partner, and I specialize in family law and other matters that involve property or business valuation issues. As you could imagine, COVID-19 and the governmental orders and responses to that, including the school closures, have had a crazy impact on family law cases like all other types of litigation, but in particular, it's thrown custody matters into disarray. And that is made worse by the fact that the courts at this point are largely only responding to what they consider to be emergency matters, and they're taking a very narrow view of what an emergency matter consists of. It's basically, in the family law context, emergency custody issues involving risks like domestic violence. So I'll start with how to handle the impact of the school closures if you are under a custody plan. So as most of you probably know, anyone who has children knows, commencing March 16th, all the school districts in Sacramento County closed for at least 3 weeks. I understand that that's been extended. We don't know how long that's going to last. There have been a lot of rumors that it may last through the end of the school year. The schools may not open back up. Other counties at about the same time as Sacramento implemented similar procedures. So I believe at this point, all schools in the state are closed. And so the question becomes, if you have minor children and you're going through a divorce, or you previously went through divorce and now you have a custody order in place pursuant to your previous marital dissolution action, you need to take a look at your custody order to determine parenting time during the school closures. No custody order has ever been written with the idea that schools would close for, weeks at a time due to a pandemic. So there's a good chance that your custody order may not be particularly clear about what happens if your school is closed for something other than your normal school holidays. So you need to take a look at that, and you also need to take a look at the child care provisions in your custody order, because you now have kids that are home from school. You may have child care needs that you weren't anticipating, particularly if you or your child's other parent is in one of the industries that is considered an essential industry, and so maybe they don't have the ability right now to work from home. And so you have kids at home and no child care for them. So you need to take a look at you know, for example, does your order require that one parent has the right of first refusal if the other parent needs childcare? Because if that's the case and you are in one of those essential industries and can't stay home with the kids, then you need to be talking to the other parent about that. Ultimately, the best way to make it through this is, and you'll hear me say this more than once, communication. You have to be in constant communication with the other parent, if possible, and try to reach an agreement with them on how to handle any child care changes during the unexpected school closures, how to handle distance learning during the school closures. I understand, of course, not every situation lends itself to communicating directly with the other parent, and if that's the case, then it's important to do that through your attorney. And you'll probably hear me say this more than once too, you should be prepared to be flexible, because it's very likely that unless a true emergency arises, you're not going to have recourse to court right now, and your order may not be particularly clear on what happens right now during these school closures that have nothing to do with summer break and have nothing to do with your normal school holidays such as spring break or, you know, Memorial Day, which for most school calendars that I've looked at, those are the only holidays between now and the end of the year. So that's school closures. The next set of questions I have relate to the shelter in place and other governmental orders and how those impact just custody issues in general, aside from the school closures. And that brings a whole host of questions up. So for example, can my kids go to play at other kids' houses? This would appear, and I'll kind of going back to what Scott had to say, the county orders were a little better. And I think the initial orders that came out of the Bay Area were not as clear. And then as additional counties made orders, they seem to be taking more into account. The statewide order does not. It certainly does not take into account things like custody transitions, which I'm going to talk about. So anyway, first question, can my kids go to play at other kids' houses? This would appear to be a violation of the governor's stay-at-home order pretty clearly. Regardless, if you choose to do something like that, if you choose to set up a play date, I would expect you'll be called on that behavior by the other party, particularly if you have a relationship, you know, if you don't have the best co-parenting relationship with your children's other parent. So our recommendation is you stay at home when the kids are in your custody. You let the children play in your yard, you let them play in the house. If you take them to the park, you know, all of the orders appear to allow family walks, but don't let them play on the equipment at the park. You can, you know, one way to keep your kids connected, because I know it's rough on everyone's kids right now, is setting up Skype and Zoom and other virtual conferences. And just as an example, my daughter's Girl Scout troop this weekend is holding their monthly meeting by way of a Zoom meeting. So that way, even though the girls can't get together in person, it gives them the opportunity to see each other while they're all out of school. Next question, can I take the children to visit with family members? That's not clear under the state order. Under some of the county orders, it would appear to be allowable, at least if there's no more than 6 people there. However, again, interaction with other people, including family members who aren't in your own household, increases the risk, and you will likely again be called on that kind of behavior by the other party. We recommend that if you do visit family members, you do it very cautiously and to ensure the health and safety, you know, maintain the 6-foot social distancing requirement. If you have young children, that's virtually impossible to do. You can't stop a 6-year-old from running up and hugging grandma. And so, frankly, the best advice here is just common sense advice. We know it's tough on everybody, but you know, except for very rare circumstances, such as someone is, you know, dying, at this point, while the statewide governmental shelter in place stays in effect, you should probably avoid visiting family members when you have custody of your kids. What if one or more of the children have compromised health issues? Again, this is frankly less of a custody issue and more of a common sense issue. You know, follow the strictest guidelines that are out there as far as the recommendations by the CDC and the other government, and don't let your children have interaction with people outside your home while they're in custody. Can I travel with my kids to a vacation home? The best answer to this one is no. You know, for all of the other reasons that I've already said. And don't forget that if you are in the middle of a dissolution action, then the automatic temporary restraining orders are currently in effect, and you can't travel outside the state of California without the written agreement of the other party anyway. I wouldn't be surprised if at some point, you know, these orders, maybe the federal government gets involved. There may be orders that prevent you from traveling outside the state. But for right now, while the shelter-in-place order remains in effect, I would not be taking your kids to a vacation home. You know, this is a big one. Does the order prohibit me from taking my children to the other parent to effectuate a custody order? Under the county orders, it's pretty clear that it doesn't. Most of the county orders are pretty specific that one of the reasons that is considered essential for travel is complying with a court order. Again, the state order is not so clear on that issue, and we have encountered situations, you know, in contentious custody matters where parties are taking the position in a dissolution that, hey, there's a stay-at-home order, I can't drive the kids to your house to effectuate a custody transition. We don't believe that's the intent of the stay-at-home order issued by the state, and based on our conversations with other family law professionals and court conference calls that are being held, the courts don't see that as the purpose of the stay-at-home order either. So for now, our recommendation is you very strictly follow the custody order if you have one, unless to do so would endanger your children. And if that's the case, then you need to be reaching out to your attorney to get advice on that as soon as possible, because what you don't want to do is put yourself in a position of being arguably in contempt of a court custody order because you're not, you know, you're refusing to abide by the court-ordered parenting plan. Finally, if you think that the other party, your children's other parent, is not following the governmental orders in a way that endangers the children or is doing something else that endangers the children, you should get in touch with your attorney as soon as possible. That is one of the few things that courts are accepting. You know, you can get into court on emergency custody issues where there's, you know, a risk of danger to the children. That's one of the few things that courts are letting you get in on. Finally, the last question I had to cover today is what happens if my child, or my child's other parent gets sick or is subject to quarantine requirements. So now is the time, while hopefully you and the children and the children's other parent are still healthy, to put a plan in place. Because again, very unlikely that your custody order covers the situation where a parent gets sick and is required to quarantine themselves. So, you know, this is an unprecedented set of circumstances. I would suggest that, you know, again, communication is the most important thing you can do, either directly with the other parent, if you have the kind of relationship that allows you to do that, or through an intermediary, such as your attorney. But you should be in contact and try to get a plan in place so that you and the other parent, you know, aren't trying to figure it out on the fly when someone gets sick. You know, essentially try to come up with a plan. It would also be a good idea to communicate with your child's other parent, again, directly or through an intermediary, to discuss how to respond if your child becomes ill. So for example, you should discuss if your child becomes ill, either with COVID-19 or with something else, which parent is going to stay home with the child? Will you continue to follow the regular parenting plan, even if the child is ill? You know, communication is the key here to hopefully head off any problems again, because there's a good chance the court may not be available to you to address those problems if they come up. And, you know, I will repeat finally what I said kind of near the beginning, which is when it comes to issues with the kids in these, you know, unprecedented circumstances that the custody orders weren't really written for, be prepared to be flexible if possible. And with that, I will hand it back to Jamie.
Thanks, Kelly. Before we do that, before I start talking at you all, a question did come up in the employment and benefits arena that Liz Stower would like to address.
Thank you, Jamie. The law has all changed. I'm just kidding. The question that was posed during my talk was whether the shelter-in-place orders trigger these 80-hour paid sick leave benefits. As every lawyer loves to say, well, it depends. I think the reality is the Department of Labor has not directly addressed this question, but if you read between the lines of the questions and answers that they have put out, I think the answer is it will never do that, because there's guidance in their questions and answers about if your business closes, your employer closes, are you entitled to this benefit? And they say no, even if the business is closed due to a federal, state, or local directive. The guidance also says that even if you're receiving the benefits, you will stop receiving the benefit if your employer closes or if you are furloughed due to lack of work. Those answers to me suggest that the shelter-in-place order in and of itself is not sufficient to trigger the quarantine or isolation issue. I see you typing at me as I speak. It's not sufficient to trigger the quarantine or isolation issue, because that's really what was contemplated when they put the law into effect. But let me say this, that certainly situations like, are you an essential business, are you otherwise meeting the requirements of making work available to these employees, might factor into that answer. And so it might be a little more context specific than simply that general answer. But I will tell you that I think generally speaking, the intention is not to have simply the shelter-in-place order trigger the entitlement for the employee to receive these benefits. And with that, I'm also happy, you know, you can always reach out to either me or anyone else in our department if you have specific questions about a particular employee or business and you want to work through these issues. Because again, of course, they are evolving and the DOL guidance literally is coming out every day. And so we're just doing our best to preempt potential issues down the road. All right, and with that, I'll turn it back to Jamie.
Thanks, Liz. Jamie Dreyer here again. Again, thanks for joining us. Echoing what Liz said and what you're all facing and what we are all seeing, things are changing on a daily basis. So we're going to try to keep ourselves up to speed. And like I said with this webinar series, keep you all up to speed. Let me start by saying we advertised this webinar with a component of the lead of our insurance coverage department, Anthony Vignola. To the extent that you RSVP'd and are participating and expected to hear from Anthony, we apologize. There were some scheduling issues that couldn't get worked out. So to the extent I'm a poor man's substitute for Anthony, I apologize. So I will address some business insurance issues, more from a higher 40,000-foot level, just some issue spotting and guidance, and we will pull Anthony back into the series in the future. A couple of different types of insurance coverage that we've had clients reach out to us about to try to navigate, to highlight for you. First is business interruption coverage. Business interruption coverage usually and typically covers losses resulting from business interruptions or cessation due to things like fires, accidents, or natural disasters. Fires is usually the big one that we've seen in the past. Business interruption insurance most typically covers losses due to and resulting from the direct physical loss, damage, or destruction to property. So for example, if as part of your policy and coverage, you've got business interruption coverage and your retail establishment, for example, or your restaurant burns down, in addition to property and other potential liability coverage, you may be able to, if you have the appropriate policy, recover for lost business. We do need to note, though, that since the SARS epidemic, many policies have specifically exclude viral or bacterial outbreaks from coverage. But policies are not uniform in this area. So what we're recommending, and the high-level comment I'm making to you, is pull out your policy and do a policy review, whether internally with your broker, with us, or whoever your trusted advisor is if you need assistance. whether you have coverage for business interruption insurance under these circumstances, resulting from this pandemic, might depend on, among other things, whether your business interruption coverage is part of your overall policy or whether you specifically paid an additional premium in order for an endorsement. Typically, purchasing that type of endorsement will provide you broader coverage. Finally, just the only last note on business interruption coverage is, I saw recently news that the state legislature of New Jersey has introduced a bill requiring insurers to pay COVID-19 business interruption claims despite the existence of a viral exclusion in applicable policies. And I just have to say, I don't see how that's going to work. I mean, when somebody purchased a policy, an insurer provided a policy that had a specific exclusion, there's constitutional and contractual issues I would be very surprised if that bill got anywhere. So I just thought it was interesting to point out to you all. A second quick note on insurance coverage is, and this document is available on our website, on March 18th, California Insurance Commissioner Lara called for a 60-day insurance premium grace period. The notice requests that all insurance companies provide their policyholders with at least a 60-day grace period to pay insurance premiums. The commissioner made the request to ensure policies are not canceled for non-payment of premiums due to the COVID-19 public health emergency. The commissioner's notice is directed to all admitted and non-admitted insurance companies that provide any insurance coverage in California, including life, health, auto, property, casualty, and other types of insurance. I haven't seen any other guidance on this issue. It's not a directive, it's a request, but it is from the insurance commissioner. And I suggest if you or your business is facing financial difficulty in making premium payments, it might be worthwhile to look at the insurance commissioner's order on our website and use that as the first step in a reach out to your provider or benefit provider. Finally, just very briefly, there is such a thing in the world as event cancellation insurance. We have a lot of association clients that have annual meetings, that put on conventions. We have nonprofit clients that have annual fundraising events. Event cancellation insurance is kind of very specialized and unique. And if you're not in that industry, you don't put on those types of events, you probably don't have it. So I'll just kind of briefly hit on that because it's probably not directly applicable to many of the people on the line. But event cancellation policies purchased prior to 2020 probably cover economic losses resulting from the cancellation of event due to coronavirus, even if the event cancellation policy has a specific exclusion for SARS or quarantines. It's possible that a coronavirus cancellation may still be covered. Again, you're going to have to do the policy and do that review. Event cancellation insurance, these policies cover either on an annual basis or are purchased for specific events, insure event-related revenue or expenses against a cancellation due to circumstances beyond the policyholder's control. Typically, it's for events like hurricanes, tornadoes, storms, earthquakes, wildfire, terrorism events, some of which these terms are specifically purchased and negotiated in the policy. So as far as insurance, event cancellation insurance, I'm going to leave there. A couple of commercial questions and issues have come up in the lending borrowing arena and in contractual issues. Some of you may have seen in the news or seen some guidance or articles or have heard the word force majeure before. So that is a type of clause that is extant in some contracts, not all. And basically, it is typically known, or how we refer to it kind of colloquially, is it excuses performance of a contract counterparty due to an act of God. That phrase actually sometimes shows up in older policies. They're a little bit more sophisticated and advanced than that now. So it's going to depend exactly if you have that type of provision in your contract, its applicability. for example, since 9/11, there's been negotiation and inclusion in such contract provisions for acts of terrorism can sometimes excuse performance of one party. Since the SARS and MERS epidemics, some of these clauses also include references to epidemics and pandemics. So if you do have a contract that has that type of clause in it, and it's triggered, and it's typically triggered by and described as an event outside the party's control, I believe that the COVID-19 pandemic qualifies. It may excuse your compliance as a contract counterparty with obligations or allow you to delay them. But typically, most of those provisions can only be triggered by, and you must demonstrate your inability to perform. So if you're just feeling insecure about performing, if you're feeling insecure about your company revenue, if you actually have the money, for example, to make a payment, or you have the ability, if you're an essential service, to generate a good or provide a service, if you're able to perform, this provision may not excuse your performance. Some clauses require reasonable attempts to perform and also require notice to the other party. I would note, just kind of anecdotally, I saw in the news maybe yesterday, maybe the day before, that the national restaurant chain Cheesecake Factory has determined to and actually issued a press release stating that they are exercising their rights under those clauses in all of their leases to not make lease payments at any of their stores, I believe, next month, and they have 450 to 500 restaurants. I don't know how that's going to play out, but just to focus kind of what we're talking about. Finally, I guess with loan and contract issues, whether you're a lender or a borrower, we are assisting people with navigating the current uncertainty in the relationship and the effect of loan documents. With a massive reduction in revenue, if you're a borrower, you may be in potential violation of certain covenants, like, for example, maintaining a minimum EBITDA or income requirement. Your borrowing base may be off. You may, under your loan documents, you have to look at such things as notifying your lender of a material adverse change in your circumstances. All of that said, for borrower clients right now, the name of the game is communication. Communicate with the lender, reach out to them. They know what you're facing. We found lenders to be obviously flexible in at least having initial conversations. If you're a lender, and for you borrowers out there who we're talking to, lenders are about to be overwhelmed. Lenders are overwhelmed with potential loan defaults, managing their existing portfolio. If you are an approved SBA lender, I'll talk about briefly next, you're about to be overwhelmed with loan applications and the loan process resulting from the massive economic stimulus package that was passed today. So let me hit some highlights of that just briefly. I was watching online this morning, actually on YouTube, a little bit of the debate and the vote in the House. And earlier in the week, the Senate passed unanimously what is called the CARE Act, which just stands for Coronavirus Aid, Relief, and Economic Security Act. The House passed it today, and the President has said he's going to sign it into law. And you've seen the big numbers. It's a $2 trillion economic stimulus package, kind of broken up into two categories. The second of which I'm not really going to talk about, which provides for funding for government agencies, and it's a massive amount of money to provide funds to keep agencies running. The first part of the bill covers 5 categories. The first major category, and the thing that our clients and we are primarily interested in, is the modifications to and creation of additional categories of small business administration loans and loan processes, and providing, I don't have the dollar amounts in front of me. It's somewhere in my notes, but
I think it's about 450 million, 450 billion, I think.
That's right. I was going to say between $400 and $500 billion available to flow through the Small Business Administration to lenders and out to borrowers. It's a substantial change to existing law. This new business loan program is 100% federally backed. It differs from current SBA loans with respect to such things as collateral is not required, personal guarantees may not be required, the interest rate is required to be kept under 4%, and there's no recourse unless the loan proceeds are used for unauthorized purposes. The definition of small business concerns for purposes of this new loan program is businesses with less than 500 employees. There's a maximum loan amount of up to $10 million, but it's capped at $10 million, I should say, and is calculated as the lesser of 2.5 times an average totally monthly payroll calculated in years past, plus any amounts if you're a business that you've previously applied for or obtained under the SBA's disaster loan program previously. The borrower requirements the threshold appears to be very low. The requirements include a good faith certification that the loan is needed to continue operations during this emergency. Funds will be used to retain workers and maintain payroll, also to make mortgage, lease, and utility payments. There's no other application pending. You can only apply once, and haven't received recent funds under the program. So, the big use that we're seeing is going to be for payroll. There's a component to this program that I won't get into all the details, but if loan proceeds under certain requirements and restrictions and calculations are used for payroll, and you maintain the size of your payroll based on a calculation, that component of this loan can be forgiven, which is huge. I should say also that this new bill that was passed today provides for deadlines for the Treasury Department to publish forms, regulations, and guidelines. I don't know the status of them. I'm not sure they exist. I don't think, from a lender's perspective, obviously they don't have the documents or application forms and things like that yet. And between 14 and 30 days, depending on the exact type of loan program that I'm talking about, is when the regulations have to be provided. So these loans aren't available. Well, they're available, but you can't apply for one and get one approved now. There's just simply no process for it, but they're going to be freeing up in the next 2 weeks. There's a whole lot more in the economic stimulus package today that we won't be able to get to. That's some of the highlights. There's some questions popping up on the board relevant to the economic stimulus package that I will try to hit briefly before we sign off. There's some questions about, let's see. There's some questions about eviction, foreclosure moratoriums, right to request forbearance and eviction protection. And really, there's a question about whether it applies to commercial mortgages, and the way we're reading the bill and from what I've seen now, there doesn't appear to be a distinction based on what I've seen. The key caveat there is that the foreclosure moratorium, right to request forbearance, and eviction protection applies to government-backed loans, so federally backed mortgage loans, which can be commercial, can be residential, and in fact, just briefly leave you with a foreclosure moratorium and a forbearance request. If you're a borrower of a federally backed mortgage loan, you can request a forbearance regardless of delinquency status and without penalties, fees, or interest by simply submitting a request to the borrower servicer and affirming financial hardship due to COVID-19. In response, the forbearance must be granted for up to 180 days and potentially extended for an additional period of 180 days. Multifamily borrowers with a federally backed multifamily mortgage loan, a little bit different. So long as loan payments were current as of February 1, those borrowers may also request a forbearance for up to 30 days with 2 additional 30-day extensions. So those are just some highlights. There's a lot more. I think next time we're going to collect the questions that have been provided. We are going to build responses into our next webinar next week. We've also received requests for further information and guidance and assistance for public agencies, construction companies, landlords and tenants in the real estate area, litigation and court services and what courts are available, and also estate planning, including such things like healthcare directives and the like. So that's a lot. You know, we're not going to be able to hit all of that next Friday, but please look for a note from us in the future. We will be having another webinar a week from today. Finally, before we leave you, appreciate your participation. This webinar was recorded, and within a few days, it will be posted to our website, which you can access and provide anybody you like. So with that, we're going to sign off, and thank you, everybody.